Ways and Means Committee. First matter we're going to consider is House Resolution 146. Representative Kirby, he is had another appointment he had to be to, so Representative Lee Hawkins is going to present that on his behalf.
Mr. Chairman, committee, before you have House Resolution 146. This is a resolution that has been repeated over the number of years, and as you see, this is to repeal the 16th Amendment and present the fair tax as the solution. That's the resolution, and I would entertain your favorable vote. Thank you.
Representative Harper, we have a question. We have a question by Representative Flood.
Thank you, Mr. Chairman. Representative Hawkins, I wanted to ask a question about line 8 of the bill. Really, line 6 through 8. So, whereas the fair tax replaces all federal, corporate, and personal taxes, does it address state taxes?
This is just federal tax.
Right. So then Georgians would keep 100% of every paycheck. That wouldn't be accurate, then, would it?
You would be correct on that. I think they're just referring to their federal tax.
But that says keep 100 Georgians to keep 100% of every paycheck.
Yes, sir, I understand.
Right.
I believe that's probably the way the resolution has been passed over the years. I'm not sure.
Even though you would support that it's inaccurate?
You know, they asked me to bring this to you. I've not heard the discussion on this or the debate, so I would leave it up to the wisdom of this committee. If you would like to amend this, that's fine by me.
Thank you.
Any further questions? Representative Martin.
Mr. Chairman, if we get to the point where we're in the posture, I'd offer an amendment to correct the gentleman's concern.
I see no more questions, so I think we have arrived at that place.
If on line 8, I would strike 100, and after the word keep, I would insert a higher or an higher. So it would read keep a higher percentage of every paycheck. A higher. I'm not an English major, Mr. Chairman.
Neither am I. Okay, you heard the motion by Representative Martin's amendment to the resolution. I have a motion. So moved to second. Moved and second that the amendment be added to the House resolution. All of those favor signify by saying aye. Opposed, no. Passes. Thank you. I'm sorry, we didn't vote on the bill. Excuse me. We amended it, but didn't vote on it. Now I call the main bill as amended. Moved and seconded. All those in favor signify by saying aye. Opposed, no. Ayes have it. Thank you. Next bill we're going to call is Senate Bill 145. Senator Heath. Yes, sir. Senator, go ahead.
Mr. Chairman, there's been a lot of discussion on this bill. I'm not exactly sure where the committee is at this point, but let me explain the underlying bill and the original intent. Currently, if you under current law, if you allow weddings to be conducted on property that's under the CUVA program, the Conservation Use Valuation Assessment Program, for hire, it can be considered to be a breach of covenant. It's not in conflict with the intent of CUVA as far as the conservation use. And so this amendment would just add the underlying bill, the language would add one more clarification there of things that would not be a breach of covenant. And that is, if you've been in the CUVA program for 1 year or more, then you could use the site for farm weddings without being a breach of covenant. So it doesn't expand CUVA in any way. It just allows you to conduct an activity that would not be in conflict with the intent of the CUVA program.
What Senator Heath is presenting is the as-passed Senate version, which is LC 34377-4SSCS, is the underlying bill. Does any member of the committee have questions of the author of the bill on the underlying bill? Representative Harrell.
At the appropriate time, Mr. Chairman, at the appropriate time, I'd like to offer a suggested amendment.
All right, sir. You going to explain your amendment?
Yes, sir. As members of the committee may be aware, and as we discussed in the subcommittee meeting, there was a modification offered previously, and we've worked on that language. So the amendment I would offer would add, in place of line 13, beginning with paragraph number 9, would read, allowing all or part of the property which has been subject to a covenant for at least 1 year to be used to host not-for-profit equestrian performance events to which spectator admission is not contingent upon an admission fee, but may provide for an entry fee for event participants. As I understand, the purpose of this is to potentially make events such as occur with our 4-H groups, to allow them to have some of these type of events, which do on occasion have an entry fee on some of these CUVA properties. That's my understanding of the intent of this amendment.
The minority leader has a question.
To Mr. Harrell, I have a friendly amendment to your amendment, more of a scrivener's, to start on line 12 with striking the period, making that a semicolon, and then adding the word or, comma.
Yes, ma'am. Thank you. Okay.
All right, is any other Representative Harvey? Representative Powell, I'm sorry, excuse me.
I have a question for the minority leader. Are you going to delete the or that was in the First Amendment?
I'm sorry?
You're going to delete the or that was in the First Amendment in line 9?
Correct. We struck it earlier, and so I was just reinserting it for the purposes of adding this subparagraph 9.
Thank you.
Representative Houston has a question.
At the proper time, I'd like to make a motion.
Now's the proper time.
Do pass. On the amendment.
You're referring to actually two amendments.
Do pass on both amendments. If we have to take them separately.
Let's start with Representative Harvey. I think
Amendment to his amendment.
that would be simpler. Thank you.
Okay. Would you like me to restate the amendment then?
Yes, sir.
All right.
If you would restate your proposed amendment.
My proposed amendment begins on line 12. Well, we'll remove the period and put in a semicolon followed by the word or, and then begin a paragraph 9, which reads, allowing all or part of the property which has been subject to a covenant for at least 1 year to be used to host not-for-profit equestrian performance events, comma, to which spectator admission is not contingent upon an admission fee, comma, but may provide for an entry fee for event participants, period.
And Representative Houston, is this, my understanding, you are moving to pass that amendment, is that
I
correct?
do.
Is that second? Second. The motion has been made and seconded to pass the Harrell Amendment. All those in favor signify by saying aye. Opposed, no. The amendment passes. Now to the main bill as amended. What's the pleasure of the committee? Do pass and a second. All those in favor signify by saying aye. Opposed, no. Thank you. Senate Bill 137, Jeffries bill.
Mr. Chairman, I'll be carrying that in the House. Senator Jeffries, for some reason, is enjoying himself so much over in the Senate. He didn't want to come over here this afternoon. So, with your permission, I'll
Yes, sir.
present.
You may proceed.
Thank you. Senate Bill 137 simply adds the Commissioner of the Department of Economic Development as a signatory in the approval process for Economic Opportunity Zone tax credits, and it has a few other cleanup provisions in the language, very just technical changes, but the substantive change is to add the Commissioner of Economic Development to that approval process.
Any Representative Martin has a question.
Mr. Chairman, I also have an amendment, AM 340611. I would like to offer at the appropriate time, and I believe your staff is handing that out at this point.
Well, right now, does anybody have any questions of the author, or the designee of the author, on the main bill before the amendment gets here? I see none, so if you would, when this gets passed out, Representative Martin, explain your amendment.
Mr. Chairman, may I have a copy of that as well?
Sure. Has everybody got a copy of the amendment? And Representative Martin, that is AM 340611, is that?
Yes, sir.
You may explain your proposed amendment.
Thank you, Mr. Chairman, members of the committee. I offer this amendment to the bill, which simply it changes the preamble so that we properly reflect what's in the legislation by inserting an applicability. And then we're seeking in lines 42 to define the time the new applications will be subject to the new procedure, and we do that at July 1st, 2013. Mr. Chairman, I had talked to your staff and folks from the governor's office also about this. The reason for so doing is it's not clear in this bill at what point new applications would be subject to it, since we don't know when the governor would sign the bill. The bill is effective upon signature, and I believe the attorney can opine further on this, but I believe you have what's called ex post facto, am I saying that correctly, situation whereby if an application has been made and the underlying process changes underneath it, it creates problematic issues. So I had two amendments drawn, one that actually had an effect, or applications after May 1st. The learned attorney for Ways and Means pointed out to me that given our sine die date and the date that the governor could possibly sign this at the latest, the law itself could become effective May 7th, so my May 1st date would in fact create an ex post facto situation of at least 6 days, perhaps 7. So we went with the Ways and Means prepared amendment for July 1st. So again, support the concept the governor's office has to have economic development commissioner as well as the DCA, commissioner of the Department of DCA involved, but would like to leave the game the same for those that are in the process. And happy to answer committee questions if there are.
Representative Peake has a question.
Thank you, Mr. Chairman. Really more to the author of the bill. How do you feel about this amendment? Are you okay with this, Governor? I know it's the governor's bill.
The governor's office opposes the amendment. It's not an ex post facto issue because we're not going to undo any exemptions that are granted, which would make it ex post facto. In fact, this would just affect, it would affect any that are in process, but it would not affect any completed exemptions that are already in law or that have already been approved by the existing law. So that issue legally is not a basis for is not a sufficient basis to amend the bill, and the governor does oppose the amendment.
Mr. Chairman, may I also address the?
Yes, sir.
If it please the chair, and
No,
I'm not an attorney, I believe the gentleman presenting the bill is, but in conversations with an attorney, my information is that when one makes an application, much like if you would make a zoning application at a city, once the application is in and a city would change the underlying zoning code, that you have a problematic situation. I am informed that creates the same situation here. That aside, I think it's a system of fairness. I mean, we're right here in March Madness. And if if somebody's driving down the court to shoot the two-point shot or the three-pointer to win the game, they fire it in there, they win the ball game, and they go over the scores table and find out that the committee has changed the rules so that the three-point shot is now only worth 2, and they find out they're in a tie game instead of winning. That's changing the rules in the middle, and I think that's what we would be doing here if we do not put a date certain that applications would be effective, and would ask the committee's indulgence to go with the July 1st date and continue to work with the governor's office if they feel like that's too far, perhaps to back it up in the future to May 7th, which would be the effective date, last possible effective date of the legislation.
Representative Martin, you're going to have plenty of time to explain yourself. There's a lot of questions.
Oh, yes, sir.
Representative Houston.
Just one thing I can't understand. We're doing this bill to try to clean up some stuff and everything. So you're saying if I applied right tomorrow, I wouldn't have to go by the new rules that I could rush your application in and not have to go by this.
Well, if I...
Yes, sir.
Okay,
Is
I
that
just
not
didn't
true?
yes, ma'am. Well, I would answer that question like this, Madam Chairman, is I don't see that we're necessarily changing rules. That brings up another interesting question. We're saying the Commissioner of Economic Development is going to be involved in the process. There are currently no rules and regulations by which the Commissioner would weigh in, so I would further state the need for this effective date is to allow them to propagate rules and regulations so people know how to make application. It seems only, otherwise we're going to stop the process for a period of time until the Economic Development Department has propagated rules, and one can only look at where jobs have located in Georgia recently. The GM site up in Rawlsville, there are others around the state that have been in opportunity zones, so I don't think we want to shut down the economy while economic development is waiting to sign off on these. So I think that the amendment would allow the process to continue for those applications that are in process or in the pipeline, because we don't know what new rules economic development may propagate, and we don't have that at all in this bill. It's silent.
Representative Black. Minority Leader Abrams.
Thank you, Mr. Chairman. To Representative Coomer, can you explain what the opposition to the bill would be, or to the amendment would be? Because I agree with Representative Martin that this creates a situation where someone has submitted a fairly comprehensive application, but and they followed the patterns that have been previously authorized as sort of the way to get these done, and with the addition of a new participant in approving this process without knowing what those conditions will be, a currently sitting application would be somehow disadvantaged and may be forced to go back to the drawing board. And given how complicated some redevelopment applications can be, especially for this type of information, what would be the grounds for not wanting to create a time certain for both parties to understand when the rules of the game change?
Sure. Well, let me answer this way. Whether you say July 1st is the date or May 1st is the date, you're essentially picking an arbitrary point in time. As the author of the amendment pointed out, he had previously said May 1st should be the date, but then found out that might actually be before the law would go into effect as it is written. So I'm not sure what the real meaning behind the amendment is, because if we're setting May 1 as the arbitrary date, but then find out that doesn't function because of the way the law may come into effect, why is July 1st any better than May 1st? Or why is it better than May 7th? Or why is it better than any other date? The point of this is to make the law effective as soon as possible, not so we can shut down the economy in Georgia, but so that we can adequately manage this process with additional oversight, and to have a better opportunity to vet these issues before we grant these opportunity zone applications.
If I can follow up, Mr. Chairman, I would argue, or at least ask, just to clarify, the purpose of setting a date is to provide notice. And so the arbitrariness of the date is less relevant than the goal, which is to provide notice to those who are in the process of completing these applications that the standards for evaluating the applications will change. And so the date, whether it's May 7th, July 1st, the date itself is not the issue. What I understand you're opposing is the provision of notice, and that's the part that I'm not clear on, because if it's simply the number, the date, if it's the month and the date, I can understand maybe there being some debate about what that should be, but I think the underlying purpose of the bill, or the underlying purpose of the amendment, is to provide notice, and I don't understand the objection to providing notice to those who are in the application process.
Well, the only distinction between the bill as drafted and the amendment, it appears to me that you're going to change the effective date. And so, I don't mean to answer a question with a question, but the only thing I can ask, or the only way I know to respond, is to say, why is July 7th or July 1st a more appropriate day than May the 7th?
So the objection is not to the date, so the objection is not to the notice, it's to the date that was selected for notice.
Well, let me say, first of all, the objection is to a change to the bill as it has been. I don't believe we should necessarily give deference to the Senate on everything they do, but I will say that it has been thoroughly vetted, not just in the Senate and in its committees, but also through this committee process, both before the full committee, 2 times in subcommittee, and now today. And up until now, the issue hasn't been presented. Frankly, I haven't seen this amendment until I received it just now. I haven't had an opportunity to vet it beyond this moment, and I would tell you that it would be irresponsible to just pick this date, set it out there, and change the bill, since the bill has already gone through so many steps in the process. I don't think that this one has been particularly well vetted, and now we're here at the last moment trying to make a change that is substantive, and frankly one that I didn't even know was coming up, because I knew there was an amendment coming. I didn't know the substance of it, so I haven't had a chance to prepare for other responses other than what I'm telling you, shooting from the hip right here as I stand here with you.
Thank you.
President Powell, wait. Representative Harrell.
I'll waive as well.
Representative Williamson.
Thank you, Mr. Chairman. My question is, it looks like the overarching goal here is to get more perspective from the Commissioner of Economic Development, and having served on the BCA board with Representative Harrell a number of years ago. They do a fantastic job there, but I really applaud this addition of the Commissioner of Economic Development, because being good stewards of these tax dollars that we're giving away, there really needs to be a little bit more oversight. You know, one thing we are good at doing is responding to situations where it's appropriate to use some tax credit driven responses, especially in subparagraph 1 where there's a sudden and severe period of economic distress, subparagraph 2 where it's adjacent to a military installation, and so on. But what I want to draw your attention to, and this is something I can speak to experience from having served on the DCA board, line 28 says any area which is within or adjacent to one or more contiguous census block groups that has a poverty, that's rated as a poverty census district. So what I'm saying is you can have a very vibrant, clean, greenfield, industrial development area that backs up and touches just at one common point a poverty census district, and this is otherwise fabulous commercial development land, but by using the strict interpretation of what they've got here, you could qualify it as an opportunity zone. And I don't think that was really the original intent of how to apply these opportunity zones. The opportunity was for the most part designed to be offered to the communities that needed it most. So I like the idea that you got this oversight from our fine, well-run Georgia Department of Economic Development that gives some additional perspective. If that was the overarching goal of including them in there, I applaud that. And given that fact, I think the sooner we put it into law, the better. But sorry for that. That's perspective that I'm not sure if that contradicts your goal or not. But.
No, Mr. Chairman, if I may.
Yes, sir.
There's a saying we learn in law school: justice delayed is justice denied. And really, what we're talking about, to follow with Vice Chairman Williams' comments and also with Chairman Houston, is oversight delayed is oversight denied. And we're trying to make sure we have adequate oversight to avoid abuse in this program. We need the oversight to happen sooner rather than later. That's what's appropriate, and that's why we're asking that the effective date be immediate.
Representative Knight.
Thank you, Mr. Chairman. And I guess this question, I know Chairman Martin had spoke with me before, and I hadn't seen this bill, but this is a true question that I've got, and I'm trying to figure this out. As far as, is this actually needed? In other words, I would think that if somehow the rules or the procedure of the application process had changed so that someone who had filled out the application process now has turned in an application which it was under an old set of rules of the criteria, maybe that would be an issue. But is it really, if all we're doing is bringing in another one, an oversight, and we're not changing the underlying rules of the game? And this is a fair question. I know we talked, Chairman Martin, I hate that I haven't had time to come and talk to you. I just read this bill for the first time. But I guess that's my question. In other words, if we really haven't changed the underlying application process and the rules and the criteria, what's really being done here is we're adding in another judge for the application process. And if that's the case, then really does the date matter? And I guess that's my thought process.
May I answer that?
Yes, sir.
Thank you, Chairman Knight. To answer your question, and to Vice Chairman Williams' question as well, we don't know if the rules have changed. I mean, I assume when we say, on the lines, and by the way, when this bill was originally introduced, they only had the Commissioner of Economic Development dealing in paragraph 4. The bill's original introduction did not have them at all dealing in paragraphs 1 or 3. So the Senate Finance Committee added 1 or 3 for the oversight. So I would suggest to you that we don't know what rules and regulations that Commissioner Kaminsky may use in economic development, nor do any of the people that have pending applications know what the Commissioner will use when he applies, in paragraph 4 or 1 or 3. The reason that I think the date is important is for applications that are in process to play by the rules that were on the books when they made the application. To the gentleman's comments of May 1st, May 7th, July 1st, and to the gentleman's comments of him not having the amendment. The amendment was given to the governor's office yesterday, and it was discussed, and in fact, I was led to believe that there wasn't a problem in what they believed. They, to be clear, did not say they were supportive of it. And this morning I got a text message and email that said they preferred the bill move forward without it being an amendment, and I respect the governor on that. I prefer giving Georgians an opportunity to address the rules that are in place, so I would respectfully disagree. So to answer Chairman Knight's question, it's simply this, that there are rules in place. There were rules propagated by the Commissioner Beatty's board by which you fill out an application. We're basically, by changing this bill, we're adding economic development. There'll be more rules. While they propagate those rules, if applications are in place right now, they're going to sit and wait on those rules to be propagated after the effective date of this bill. And I think that stops the process.
Representative Powell, if you want to be heard, if you're a member of the committee, hit your red button.
At the appropriate time, I'd like to make a motion as to the amendment.
Mr. Chairman, with due respect, it's my amendment. I prefer to make my own motion.
Well, then I'd like to second yours.
Okay.
Well, we can't have it one at a time. We've already had, who was last? Representative Harrell, I think, is eagerly wanting to have information imparted to him.
Thank you, Mr. Chairman. Irrespective of what rules may or may not be promulgated in the future, preparing a presentation, an application packet, understanding today that it will be submitted to the Department of Community, and I support the bill having the oversight of the Department of Economic Development. I think that's a wonderful idea. But preparing a presentation packet for the Department of Community Affairs today, I'm going to target that packet for my buyer, DCA. And I'm going to target the strengths that I'm presenting to that department. And I've spent time understanding that department, understanding the reviewers in that department, and how they are most likely to evaluate my proposal to gain success. Now, we're adding, and I think a very wise move, another reviewer, another oversight. But I might tailor that proposal slightly differently to talk to issues important from an economic development standpoint, or that might score a little higher with that type of review and that type of oversight differently than DCA. So I think Chairman Martin has a very valid point. There could be applications in process that money is being spent and time being spent putting together applications targeting a particular reviewer. Then on this date, all of a sudden, there's another set of eyes, which I appreciate. But so I think it is actually a very valid, and as Leader Abrams mentioned, really notice to the person that are preparing the application. Now there will be multiple reviewers that may review your application from different perspectives. So I would just be interested in understand that this is not, your bill, and necessarily we're prepared to speak to this, but what your response might be to that. I prepare applications frequently for the company I'm with, and it would certainly affect my presentation if I knew my buyer was a different party.
Representative Peake.
Thank you, Mr. Chairman. It appears that we just have some disagreement from a legal standpoint of whether this thing is actually needed. And I think that's the bottom line here. It doesn't appear, and I'm not a lawyer, I don't pretend to be, but it doesn't appear that it's needed. And is that the assessment from the lawyer that is presenting the bill, as well as the fact that your still position is that you do not are supportive of this amendment? Is that correct?
That's correct. And not just my position, but also the position of the other attorneys who have reviewed this bill through the process, including Legislative Counsel and the lawyers from the governor's, governor's council also have all reviewed this bill and all agree that this does not create an ex post facto issue.
And so in your opinion, it would be better that we just vote down the amendment at this time. Is that correct?
That is, Mr. Chairman, may I say one additional comment?
Yes, sir.
We're
about to vote here.
Okay, just to answer Representative Harrell's questions, if the application contains valid, fact-based information, regardless of how you may shade it to appeal to one party or another, if the basis of the application is valid under the law and the purpose of the law, then you're not going to have a real change to the substance of the application. You might have a change to some of the window dressing, but if it's a good application, it's going to be approved. If there's a problem in the application, additional oversight is just going to save taxpayers money. We don't want to wait for those oversight savings. We want them to occur sooner rather than later.
Representative Powell, did you have questions, sir?
I think Mr. Martin has changed his mind and wants me to make his motion for him if it'll stop debate.
You are recognized for a motion.
Make a motion to adopt the amendment AM 340611.
Is there a second? Second. All those in favor of the amendment signify by saying aye.
Aye.
Opposed, no. No. Ayes have it.
Mr. Chairman.
All right, you're certainly entitled to a hand count if that's what you request. All those in favor of the amendment signify by raising your hand. Those opposed to the amendment, raise your hand. The amendment passes.
Mr. Chairman, I'd make a motion that the underlying bill as amended pass.
Second.
Motion made and seconded. All those in favor of the motion signify by saying aye.
Aye.
Opposed, no. Bill passes. Senate Bill 224.
Thank you, Mr. Chairman. I'm here on Senate Bill 224, which will set up a vehicle for creating an Invest Georgia fund that will provide capital, seed capital, as well as early stage capital for small technology and bioscience companies in Georgia. As many of you know, this bill mirrors a bill that Representative Peake has introduced. This bill came about, the Lieutenant Governor and I, along with Representative Williamson, Representative Peake, and others, met 3 or 4 times over the summer with a number of distinguished venture capitalists, and as well as other business folks interested in this. Mainly the interest comes because states outside of Georgia are rating Georgia companies, and all of our sister states, with the exception of Alabama, have a venture capital firm, and they're coming in, and we've lost 25 companies, I believe, in the last 6 or 8 years because they come in after we've created and incubated all these technology companies. They're enticed to leave. So that is the purpose of the bill, Mr. Chairman. Again, it mirrors Representative Peake's bill. I will say, minus the funding mechanism is not in the bill. The subcommittee made another change where they stripped out the amount of money that would go to the fund, which I agreed to, I believe, yesterday.
Representative Flood.
said the vehicle for this funding would come at a later.
Is there a funding level that is?
There was a goal originally over 5 years.
Representative Peak.
President Flood, I just answered your question. Yeah, Senator Golden did answer it correctly. The purpose of this and then where we got to after 3 years of work is making sure we have the structure when this body believes that it's appropriate time to invest some taxpayer dollars into bill, and this especially sets up.
Representative Williamson. He waves. Questions by members of the committee? Not what's do pass in a second. All those in favor signify by saying aye. Opposed, no. Thank you, Senator.
Mr. Chairman, thank you. Members of the committee, thank you.
Senate Bill 92, Senator Ford was not here. Is there a designee for him? From where? Oh, okay. This is our last bill. I mean, we'd be happy to. I know his time today, but okay. Welcome, Senator Ford. Your bill is up. Senate Bill 92. The author of that amendment is not present. He's on his committee, but he's not here. Any further questions of I'm sorry, Representative Houston, excuse me.
Somebody explained the amendment too. I really didn't understand it, and I wanted some explanation. I didn't understand it yesterday, and I don't understand it today.
Representative Peake.
Mr. Chairman, at the appropriate time, there was some confusion about this amendment. I think there has been some confusion ever since, and I'd like to, at the proper time, move that we strike lines 33 through 36 from the bill.
Which will, if I understand you, what you may be wanting to do is restore the bill to its original.
That's correct, yes, sir.
Representative Stevens, Nicky Stevens.
It's my understanding, Mr. Chairman, that Representative Stevens would like to keep that amendment in the bill.
Well, he's not here, and any member of this committee has a right to offer their own amendment. Whether he, I mean, this committee will decide that is what I'm trying to say.
Mr. Chairman, if I could add, all due respect to both senators, Representative Stevens, I think there was enough confusion about this particular language that was added that I think it may be in the best interest that we, at this time, remove that portion. But we'll leave that up to the will of the committee.
I respectfully disagree with you.
Mr. Chair.
Yes, sir.
I was entirely amenable yesterday to adding that language. At the same time, it was, I think, mutually agreed that if that amendment was of such a nature to create a problem for the underlying bill, then the author of the amendment would not have a problem with it coming out. I think that was kind of mutually agreed on at that time. But I understand it's the will of the committee on how it would like to go forward.
Well, hopefully we can sort that out with a vote to see, if members are still have some concern with that part of it or don't understand it or whatever the case may be. It's that time of year where we all have to be two places at one time, and I'm very sorry that Representative Stevens, Ron Stevens, is not here to speak to the issue, but at any rate,
Chairman, move make a motion.
Mr. Representative Pack.
Thank you, Mr. Chairman. Question to Senator Ford.
Yes, sir.
Was the amendment, as I read it, I'm just trying to get background, it looks like lines 33, 36 were placed in there so that the excise tax could be used for operation expenses for any public transit, excluding MARTA. That's the way I read it. Was that the discussion you had with the author of the amendment?
I think that may have been the way it was explained yesterday. I'm not going to speak for him, but I think the language is fairly obvious.
Thank you.
Representative Peake.
Yes, Mr. Chairman, move at the proper time. Make a motion on the amendment.
Now's the time. There's no more questions.
Move make an amendment to strike lines 33 through 36 of the bill.
Motion been made and seconded. All those in favor signify by saying aye.
Aye.
We are calling the question. And let me start back over. Those in favor of the motion signify by saying aye.
Aye.
Opposed, no. We'll need a hand count. Those in favor, raise your hand.
Of removing of the amendment.
Yes. Yep. In favor of the amendment, raise your hand.
To strike it. To strike. Strike.
And those who do not favor the amendment say no. Or, I'm sorry, raise your hand. The amendment passes 8-5.
Mr. Chairman, I move to pass on the bill as amended.
Is there a second to his motion? Motion made and second. All those in favor signify by saying aye.
Aye.
Opposed, no. Bill passes. Thank you. Senate Bill 243 was, thanks, sir, was on the agenda today. At request of people involved in the bill, it will be postponed. That concludes our business. Thank you very much.